concurrency. These issues are critical for linear projects, especially in the infrastructure, energy, and transportation space, where the impacts of delay and effective sequencing can make or break a project. So a quick disclaimer before we start today. The views expressed today are like cricket commentary. They are fun, insightful, but not binding on any members of the panel. Everything you hear today, sharing ideas by our expert panels, as friendly experts, lawyers, and arbitrators. So please don't quote it back to them in their hearings. And if you do, they will deny it and blame me. I'm delighted to be joined by an expert panel today. Garry is Managing Director at Kroll's Expert Services Practice in Singapore and globally recognized authority on delay disputes. With over 35 years of planning and programming experience across engineering, oil and gas, transportation, and infrastructure sectors. He has also regularly acted as an expert witness, testifying in more than 30 international hearings, including 4 here in India. Samir Parekh is the managing partner of Parekh & Co., one of India's leading law firms specialized in construction and infrastructure law. With over 30 years of experience, he is an advocate on record at the Supreme Court of India and is widely recognized for his expertise in international arbitration and complex construction disputes, having appeared in over 100 arbitrations under the SIAC, ICC, and other major institutional rules. Atul Sharma is the executive chairman of Denton's Link Legal. He has over 40 years of experience in disputes. He advises on complex infrastructure and energy projects, representing clients in courts and international arbitration across light and heavy rail, airports, ports, housing, and other construction projects. Richard Harding is a leading barrister at Keating Chambers, specializing in international arbitration of construction and engineering disputes. Called to the bar in 1992 and appointed Silk in 2009, he is renowned for handling multi-billion-dollar infrastructure cases across the Middle East and beyond. Manish Khilauria is the Managing Director and CEO of Protocon, an IITN and a certified project management professional. He brings more than 3 decades of experience in project controls and forensic delay. He has led planning and claims management for mega oil and gas and infrastructure projects, including on India's first bullet train projects and the dedicated freight corridor. We're going to start today by looking at a little bit of depth at what is a linear project, and then dig into some of the frequent issues that we encounter. Can I invite Garry to get us started?
Yep. Thank you, Mohammed. Good afternoon, everybody. So I think what I'm going to do just for a brief 10-minute period is really just set the scene in the context of linear projects, and also the characteristics of linear projects, why they differ from non-linear projects, and what are the issues that tend to arise or have to be considered, both from a planning and programming perspective, but also from a dispute and delay perspective. And then from that, there will obviously be further presentations and discussions when we drill down into the issues which are relevant to delay on these types of projects, and also concurrent delay as an issue on linear projects. So, briefly, non-linear projects are effectively our traditional projects. Okay, these are where there's a large number of discrete activities performed over relatively small areas. They're standalone projects in the context of power plants, industrial buildings, high-rise buildings, and the like. Linear projects, as the name suggests, are effectively laid in straight lines, are typically represented by highways, tunnels, pipelines, metro rail, canals, electric lines, and so we call them linear. Now, the important point to remember here, because it's an issue that arises when we look at what traditionally we call a non-linear project, is that it's very rare you actually get a standalone linear project. There are always elements of non-linear projects within an overall linear project. So if we take, for example, a rail, the rail itself and the track is linear, but we have stations and we have bridges, which in reality aren't linear projects. If we take roads, for example, we have roads which are linear, But we also have discrete bridges and large intersections, which in themselves aren't linear projects, they're non-linear. And then with pipelines, typically we will have large pumping stations along the run. So when we talk about a linear project, in the main, we're talking about an overall linear project, but there are elements and non-linear elements within it. And the interface between the linear and the non-linear is important, both in the context of how we plan those works and the methods we use, but also when we're assessing delay in the context of a linear project that has non-linear elements, and therefore it requires different approaches for different discrete parts of the projects. There isn't just a one answer to analysing delay and concurrency on a linear project. So, characteristics really just summarised here. Linear projects are effectively a number of repetitive activities that move from one end of an alignment, by the project, to the other. Typically, we say we start here and we end here, but in most of these projects there is a sequence, a planned sequence, and we'll come on to why there are planned sequences. So linear projects don't tend to start from one end and end at one end. They tend to start from discrete sections within the linear alignment. And again, this is going to be an important issue when we look at delay. And they're flexible in that context because we're repetitively undertaking activities from point A to point B, but we can do the same activities from point D to point E. Again, but it all depends upon what the original planned sequence was when we split the alignment. So we have effectively a continuous movement of activities and labour along the right of way or the alignment. And this is an important point because the key difference between linear projects and non-linear projects in the context of how we plan them and then how we analyse delay is the fact that they're typically resource-based and resource-driven, and we use productivity and resources in order to come up with our plan. And in that context, we will analyse productivity and resources when we're looking at delay for the linear sections of the project, as opposed to the traditional non-linear projects where the approach to planning and the approach to analysing delay is different, and we'll come on to that later. So the key challenges in routing linear projects, these are the big six that I typically experience, and some of these will come up in our later discussions. But as you can appreciate, when we're looking about this in the context of the linear element of the project, and again, these are in no particular order, it's your usual suspects at the beginning. It's site conditions, ground conditions. Obviously, because we're building a road or rail, we have physical constraints related to topography, mountains and rivers and water bodies, which are limiting the alignment. We have complex regulations, approval from authorities, obtaining permits and access issues. And this is in part linked to the one in red, and it's in red because typically on these types of projects, not just in India, but elsewhere around the region, land acquisition issues tend to be the originating issue that causes delays to these types of projects, and we'll give some examples of those later. And then we have multiple stakeholders, and that's multiple stakeholders in the context of really looking at not the contractor, the subcontractor, and the owner and the engineer, but multiple stakeholders in terms of the people and the businesses that tend or will have to be moved to allow the right of way and to allow us to construct our linear works. And that's linked in with the permitting and the approvals, because most linear projects, the large linear projects, particularly in India, will cross state boundaries, and therefore there are different standards, different rules, different permitting obligations, and different ways of dealing with access and different ways of compensating people who are being moved. So there are multiple stakeholders, and again, where we do get a change in the plan, that causes further ripple effect delays. And then obviously we have things we can't control, unfortunately, which is climate change and natural hazards, which have an impact upon the topographical issues. So these really are the challenges from the perspective of planning these projects. And we'll talk about allocation of risk with these particular issues and how they're slightly different than the traditional non-linear projects later. So I'm not going to go into detail. I just wanted to make a point here, and this will be explained a bit later. Linear planning and schedule techniques is different to your traditional non-linear. So I think most people in the audience would be aware of CPM, critical path methodology, Gantt charts, bar charts, all nice and colourful. The use of programming software, that's typically what we use for non-linear projects. However, when we approach linear projects, because of the way that they are not only sequential and repetitive, but driven by resources, we have different techniques in order to plan. And these different techniques are relevant to how we go about not only analysing delay, but presenting the analysis. We will be presenting it not in the form of a as-planned, as-built programme, but in the form of different types of charts and different types of mechanisms. So these are just some of the typical methodologies that are used to help us when we're planning these projects and also to help us when we're trying to analyse delay. And I'm not going to go into detail on them, but I'm just going to give you a brief example. So you can see this is linear scheduling for a bored tunnel over a length of an alignment with the dates. So as you can see, it's very simple in the context of planning in this particular example, and it graphically represents the plan for the work and the sequence of the work, where that work's going to be undertaken, and also the period in which that work's going to be undertaken. And this is drastically different from your typical looking at programs and the way that we plan and present analysis for the purposes of non-linear projects. And we're going to be looking at some of these later in the context of the analysis of delay. So the key takeaway, I think, is that when we talk about a linear project, we must remember that there is also a non-linear element. And the interface between the non-linear and the linear is important, because if we get delays in the non-linear, that could impact the linear element of the project. So there is a key interface between two different types of work and two different types of way we plan and the way we analyse delays. And so therefore, it's not as easy as one would think. And in my experience, I tend to find that whilst it's an overall linear project, it is in fact comprises a significant element of non-linear works, which have significant issues related to delaying the linear aspects of the project. So that's all I wanted to say for that introduction.
Great, thank you for that, Garry. I think the important theme there was about drawing the distinction between linear and non-linear aspects of projects. So maybe I can just poll the panel a little bit on that. Samir, maybe starting with you. Where do we draw the line between a linear project and a non-linear project? Are there kind of hybrid models, and how does it impact claim and contract management?
Okay, so linear projects, of course. Okay, so I'll answer it in two different ways. Linear projects, as you normally understand, is something where you're going in a straight line, you're probably crossing boundaries of states, etc. But the key point is, are you doing repetitive activities where you can work out the rate of progress? So tunneling actually is the best example. And road, railway, there are certain peculiar features which we'll go into. But essentially, can you decide the rate that per month or per day you'll do 2 kilometers per day? So those are linear projects. Now, obviously, as Garry rightly said, sometimes they're combined with non-linear projects and sometimes they're not. And sometimes because the linear projects have multiple activities, you still cannot do the analysis of these projects as a linear project. So again, from an analysis point of view, it's basically where you have a rate of progress that you can determine would be a linear project.
Sure, and Manish, I know from our previous discussions, you have some thoughts about the management of these kind of projects.
Definitely. Actually, what happens, as Garry also said and Mr. Parekh also said, the linear projects are a combination of a stationed project and a linear project. So when you are developing a Primavera program, the one has to be very careful about selecting the WBS. You have the facility of creating WBS. So when you are creating a WBS, I mean work breakdown structure, you have to plan the activities of linear activities under a one segment, one WBS, and those non-linear project type of activities under different WBS. So what will happen ultimately when the delay has happened? it would be very easy for you to recognize whether it was a linear portion of the project which got delayed, or it was a non-linear, say station has got delayed. So that way, the tools are there in the market, but I see people mix up linear and non-linear project while scheduling the program. So that is where I believe that the tools are there. We can always plan things differently within a single schedule, non-linear as well as linear projects, and then the delay analysis can be done very categorically for the non-linear projects and for the linear projects. I hope I made some point.
Just wanted to add that some projects can look linear, but in fact be a combination of a large number of small non-linear projects. I was counsel for the government of Dubai in the Dubai Metro dispute. And the Metro, of course, looks like a linear project. It's a railway that stretches all the way through Dubai. But the delay was caused at the stations, and it was caused at almost all of the piers that hold up the viaduct along which the railway runs. So the delay analysis really related to the progress of these many individual areas, and then trying to ascertain which of those was the greatest delay and therefore on the critical path. So it was a deceptively non-linear analysis.
That's a very interesting point, and it sort of leads me to my second thought, which I might ask Atul to take up, which is, given where we're going with infrastructure projects and how complex they are getting, do we need to update our definition of what a linear project actually is?
Yes, of course, we need to, as everybody on the panel said, that a linear project is not purely linear all through its life cycle. But I think we go to the basic point here, and my take there is that is a delay analysis a tool, is LSM a tool, or it is something which you do post facto? So from that perspective, I think there has to be a hybrid, but I doubt if in most of the projects you will have a pure LSM coming to your rescue, particularly because record keeping is something which is so critical in an LSM analysis. And if you have continuous activities, all right, but we had this typical problem which we encountered in a metro project in Hyderabad. LSM doesn't take care of, complete obstructions to the project. And that's where disruptions is something which it doesn't take care of. So you have to have a very clear demarcation at the project implementation stage rather than coming later and analyzing each segment of the project and then arriving at the conclusion as to what tools you need. So typically, in some ways, I would say that it's an antithesis when you're talking of delay analysis. At which level, what project's life cycle you're talking of this analysis? Is it during implementation or is it post? So typically for us lawyers, the problem is always surfaces post. So that's when you don't know whether it's really going to be a solution to the problem, the LSM, but we all have to resort to CPM at the end of the day, and that's how the tribunals, the court system is all geared up.
Well,
Sure.
but I also have one extra point. Actually, if you see the project management institute, PMI, they always say that when you have a multiple type of project within a one particular big project, they call it a program. And this is the right definition of a linear project, especially the railways or metros when you are talking, because you have multiple stations that sometimes becomes more critical than having the linear nature of the project. You have your viaduct is ready, but your stations are not ready. So the better terminology in the sense what you have asked is we should call them as a linear programs rather than linear projects, because projects are under that. Maybe section 1, section 2, within that there is a linear, there is a non-linear segment. So that terminology probably the industry has to adopt, which Americans have adopted as of now. Thank you.
Okay, I think we will move the discussion on in light of that. Can I invite Samir to share with us something about risk allocation and contract drafting for linear projects?
Thank you, Mohammed. And lovely to see all of you this afternoon after a good lunch that SCL provided. So I'm a lawyer who does understand some bit of programming. So I've tried to bring out certain issues which arise. And I've also indicated how in linear projects it's so easy to do delay analysis even without experts, which all of us, and of course there are so many experts in this group also, can do. So let me just start and this is up, is this one? Yeah, okay. So, of course, what are linear projects? So subject to the caveat that all the panelists had, road, railways, pipeline, tunnel, transmission line, bridges, utilities, and telecommunication. And as most of you would realize, and of course it's not accurate statistics, but probably 70–80% of projects that are going on tend to be linear projects, and therefore they are the most critical kind of projects that we're concerned with. Now, why are linear projects different? They're really repetitive activities. Rate of progress can be easily determined, and the cause of delays can also be easily determined, and I'll go a little bit into that. I will have some diagrams which will also help. Now, what is the importance of linear projects? Very briefly, a very large portion of construction contracts are linear projects. They relate to important infrastructure work. They tend to be long duration and cover large distances. Then they can have multiple parties with requirement for coordination. And all contractors are involved in linear projects in the sense all projects will also have linear aspects of the project. Now, how do you do a delay analysis in case of a linear project? Now, I'm just showing this and I'm not going to read this. These are the typical methods of delay analysis that you're all familiar with, which is under clause 11.5 of the SCL protocol. But SCL protocol also has alternate methods, which are given in 11.7, and very often we don't use it. And I'm going to go into one of these and I'll explain why. So these are the other 11.7 SCL provides these other methods, which are 5 other methods. Project-wide retrospective as planned versus as built. Time chainage. I'm going to go into time chainage and I'll explain why. Line of balance analysis, resource curve analysis, and earned value analysis. Now these are all very useful in certain cases, especially when you get into trouble with the other methods, data not available, etc. And it is possible when you don't have the as-built schedule sometimes to do one of these analyses to reach the objective that you want to. Now I'm going to drill down, going further from what Garry told us, into one of these methods, which is the use of time chainage method. And why do you use time chainage? It's easy, effective way of carrying out delay analysis in linear projects. And I'm suggesting that it can be effectively used both by in-house counsels and planners and company planners. Now let me go a little bit further. Now, what is a time chainage chart? And I'll be showing the chart, but just to start with, also known as time distance or time location, is an extension of the bar chart method, the very basic methods, and again, in India, we use that very often. And it uses a horizontal axis to represent time and vertical axis to show distance. So, and you'll just, I'll just come to that, I'll explain this further. It's simple, visually easy to understand, and be carried out by most planners. Now let me show you a baseline time chainage diagram. I hope all of you can see it. On the bottom, the x-axis are the months, so month 1, month 2, which can be whatever period of time. And the y-axis is the chainage, which is in kilometers in this case. So we take a tunneling project as an example. So first 2 months is mobilization. So no work is happening. If you have mobilization for 2 months, the time keeps passing, but the y-axis doesn't move. So I hope you can see that. So first 2 months is mobilization, and then the table goes up at 2 kilometers per month. So every month, 2 kilometers of work should happen. So this is the as-planned baseline schedule for a tunneling project. Now let's go forward and see how to do the analysis. Suppose this is the first step I take, a simple version, where there's a suspension of work by the employer. Now, if you can see the yellow line, and yeah, so the first line is what the baseline was. This is how you were supposed to go. And the work was suspended by the employer for, say, 2 or 3 months. So this 3 months, the time will keep moving, but the y-axis will not change. So once you come back here, you will return to the progress rate as you had originally planned. Now, if you take out those 3 months of suspension of work by the employer, at the top, those 3 months will become the contractor's entitlement to EOT, extension of time. So if I can move forward from there. Now, suppose there are 2 events instead of 1. So the first one is the yellow one, which is the suspension of work by the employer. Now you proceed after the suspension is lifted, you go ahead at the same rate as you were originally planning to go. In this case, I've shown 2 kilometers per month. But you reach an adverse geological occurrence. So you are no longer able to proceed at the speed originally planned. So instead of 2 kilometers per month, you are now proceeding at 1 kilometer per month. Now if you see this blue line is how you would progress theoretically. Namely, now you've slowed down from 2 kilometers per month to 1 kilometer per month. So the slope of this line moves so as to show when you will theoretically complete the works. Now this is still theoretical in the sense the as built is not shown here. You have the baseline and this is the entitlement. Now based on whether you finish before this or after this, so this is your entitlement. If you finish after this, then you are in delay despite the extension of time. And if you finish before, then either you mitigated or accelerated, and I'll discuss that a little more in the next few slides. Now, one of the issues of this session is concurrent delay. And of course, with programming, it's very hard to both understand or explain what the concurrent delay is. Now, in a linear project, it becomes really, really simple. So now you have the first line, which clearly shows the baseline. Now, the yellow line now is a mix. You have a suspension by the employer and the breakdown of the tunnel boring machine. So one delay attributable to the employer, that's the suspension work, employer delay, and the same period, your machine was also not working. So therefore, as the red arrow shows, this is the concurrent delay. Now if you go forward, once the concurrent delay is over, you keep moving, and you're going ahead, and again, there is some delay happens, and you move forward, and then you come here. Now, why have I shown this? This is a second contractor delay. So suppose here you reach the adverse geological event. Now, this is where you should have finished. But where you actually finish is here. In which case, this is the employer's delay, and this is the contractor's delay, plus there is a concurrent delay. So everything that you would argue in most, so to say, arbitrations is explained by this kind of diagram. If I go forward, now I want to explain something further, which is often missed out, which is mitigation or acceleration measures. Now I've worked on the same table as the last one, which is that the baseline program, then you have a suspension, then you move forward, you get an adverse geological event. Then there is a contract delay, breakdown of TBM, say the yellow line. Now once the yellow line gets over, so the contractor's delay is over, you go back to the place you would be, but for that delay, which is this line. But then towards the end, you accelerate the work and you still finish in time. So this is where I've raised the question. One, this is your entitlement to extension of time. There was a concurrent delay, but you finished within the actual time. Therefore, you actually accelerated the work. Now again, some experts have different views in the matter, but according to me, very clearly, if you put in additional resources and complete it in time, although there is concurrent delay, it would not amount to concurrent delay for denying you compensation. And that again comes out very nicely through a chart like this. Now, again, so this is mitigation and acceleration, similar, same chart actually, but where you actually finished even before your entitlement to time. So you are entitled to time till here, but you finished before that, so you actually accelerated. And that's another issue that many experts also face. How do you show acceleration? How do you show mitigation? In a time change diagram, here you've shown it. Your entitlement time is here, but you actually finished here. Were you instructed to do acceleration? Did you mitigate on your own? Either way, you will not get time beyond this, but do you get any further compensation for this? So really, this shows all the issues that arise. Now, this is something, this is on the same line, but this is more complex. It kind of shows multiple things, but this is what actual bar chart line diagram would look like in a project. This is the original as planned. Then there is a suspension of work, and it was geological occurrence. But suppose here the red line at the bottom shows that you actually don't progress, so you take 3 extra months to mobilize. So your completion date will actually move back. So again, you will have a original completion, entitlement to time, and delays by the contractor. So this is a nice, simple way of carrying out delay analysis. Now, when can you not do it? It's again, I just put down a couple of points, and again, it came out when on Mohammed's reply to Mohammed's question. It's the simplest and easiest form of delay analysis and works very well in case of linear project. However, it often fails when land handover or access is given patches and cannot easily be plotted, where there's coordination requirement and lack of data of actual progress. So that's where it kind of fails, where you have multiple layers. Again, I forget, but one of the panelists mentioned, suppose you have to do earthwork, then somebody else has to do some other work before you go to track laying. Now, both might be linear projects, but it may not be easy to plot it. So sometimes you can do this in parts, sometimes you can do it in details. So that's, so therefore time change doesn't always work, but some portions of the progress often can be shown by time change. So thank you so much.
So I think two of the important points we can take from that is the method of delay analysis changes. And the key thing we are looking at is rate of progress across that time. Garry, I wonder if I can bring you in. If we just take a step back, does that mean we need to rethink the way we look at contractual risk allocation and the kinds of delay events that matter when it comes to linear projects?
Yeah, and I think going back to the key challenges with linear projects that I mentioned earlier on, particularly in the context of access and land acquisition issues. I mean, typically, from an equitable standpoint, as a planner, one looks at the risk, and he who can manage the risk and control the risk should be the one who takes the risk. That's typically the equitable approach to construction contracts. Obviously, it's not always done like that, but that's the way one should approach it. Given the common issues related around land acquisition, approvals, regulations, multiple stakeholders and access issues, I think there is a need for linear-driven projects, which are overall linear, to make sure that the party who is best able to manage and control that risk, which is not the contractor, should take responsibility under the contract to deal with those issues. And I have seen contracts where the contractor has to take responsibility for dealing with the villagers where the right-of-way is going, which patently isn't right. It should be dealt with beforehand by the employer to deal with the government and to deal with the locals in terms of creating a right-of-way and dealing with the compensation for the crops and for the villagers. But it was given to the contractor to deal with, and the contractor isn't placed to deal with that. So I think there has to be careful consideration for linear projects, particularly in the context of highways and rail, and where there is an existing population and right-of-way is a big issue. The contract should clearly delineate responsibility for those issues to the employer.
Can I join you, Manish, to give us some of the Indian perspective on these sorts of risk allocation challenges?
Yes. Sure. Many times I have observed this risk allocation has not been done fairly, to be very honest. I worked on behalf of employer also. I worked on behalf of contractors also. I will give you one simple example. I have seen many of the, I would say, linear programs, when their tender has been prepared, you keep some certain milestones, intermediate milestones from change this to change this. The project completion, milestone completion date is this. Then say if it is a 100-kilometer project, you will divide it into 10 kilometer and you define the intermediate milestone date. But at the same time, global level, when you define the ROW allocation in the contract, the employers will cleverly put that I will give you 50% handover of land on the first day, another 30% in 6 months' time, another balance 20% in 365 days. Now, what kind of risk allocation you see? You are expecting a contractor to finish first 10 kilometer within this period, but within that, when you are giving the work front to him or the right of use, the first right of way, the first 10 kilometers you have held back because you don't have the front available, it is not available, and then you are giving in after a year. So what kind of risk allocation is? This is a poorly managed contract, and this is where the disputes happens. If the contract terms are clear, that you have to construct first 10 kilometer in say 365 days, second in another 6 months time, then you have to, the ROU handover should also be aligned with such type of milestones, then only the disputes can be avoided. Otherwise, it's a vague requirement by the client, because client would always argue that I have given the 50% land, but if that land is not applicable for that particular change where your milestone has to be met, it is of no use. I hope I'm able to, maybe Garry can add something.
Yeah, I mean, from a contractor's perspective, what he's interested in is not necessarily how much chainage he's going to get at different phases. He wants to know where, what order. Yes. Because particularly for a rail project, I mean, I did a rail project in South Africa where we had 2 discrete sections, and the contractor had to have his own precast unit production yard, his yard where he stored his rail and he did his butt welding. He put that at the beginning of the alignment, and then he had a second one about 50 kilometres north for the second section. And he's going to run his project and bring his sleepers and his rail onto the rail, the track laying, and it goes sequentially. What happened there is the first 10 kilometres of the first section wasn't made available because of access issues. So he had to get a small plot of land 10 kilometres up the road, go through the permitting and axing process. It was not sufficient to do any production work. He then had to transport by road his sleepers and his rail to this little laydown yard and then construct from that. Now that had a serious impact on the project because he was told the sequence in which the works were going to be undertaken, and there was a change in sequence. So therefore, from a contractor's perspective and from a delay analysis perspective, we need to understand what the sequence was in the context of the order of the alignment, because that has significant ramifications in the logistics of undertaking an alignment type project.
Can I
Definitely.
join Atul to comment?
I think in the Indian context particularly, one of the biggest problems is that the risk allocation is at 2 or 3 levels. The first is the concession, because the PPP is very, very live in India. So the tendency of the concessionaire is to just pass on those risks to the contractor. In the first place, the concessioning authority has not been fair in risk allocation. Then it comes down to the contractor, and then the contractor has no option but to bear that risk, notwithstanding that even the concessionaire is not going to be able to deal with it. So in that sense, risk allocation is something which always is the cause of most of the disputes, particularly in India, road projects, whether it's metros, in all linear projects, and for that matter, all projects. And for example, we have this case going on where the issue was who is to take the permission for removal of utilities, right? The clause is that the concessionaire will be given, or rather the contractor will support, will get the clearance, but he'll get all the support from the employer. Now, what kind of risk allocation is this? Virtually the whole risk is sitting with the contractor, but because the principal or the employer is a government body, they are the guys who can do it much better. So that's where the whole problem arises in risk allocation, and risk allocation really messes up most of the programs and handling of the risks.
Very true.
I think it's important to distinguish between risk allocation as a matter of negotiation before the contract is entered into. There may be all sorts of commercial reasons why the risks are allocated the way they are. There may be financial benefits to the contractor or other benefits. Once it comes to me as an arbitrator, the contract is the contract. It's not for me to decide whether the risk allocation is good, bad, indifferent, unfair. I have to apply what the parties have agreed. And just following on, I think from Atul, about the majority, but a very large percentage of the disputes that reach me have gone wrong the day that the contract was signed, and it was almost inevitable that there was going to be a problem because for whatever commercial reason, the contractor has signed up for something he can't deliver.
And that's where employers are misusing this opportunity. So they are making one-sided contract, and the contractors, because they want work, so they will keep on signing.
Okay, so we've set the risk allocation matrix, and we looked a little bit at the delay analysis methodologies. I'm going to invite Manish to take us a little bit deeper now into the delay analysis methods.
Thank you, Mohammed. Please allow me to give this presentation while I'm standing. It is very difficult for me to give a presentation while sitting. Very warm welcome to all of you. Probably the most controversial presentation I'm going to make, because this is where every problem lies. And believe me, I always believe that most of the problems of these disputes are being created by either a delay analyst or a dirty forensic consultant like me, who has given this education. Rather, he has increased the greed of the claimant by giving him the fake opportunity, telling him that I will convert your failure into an opportunity. Trust me, guys, I have worked in India for so long, especially in companies like Engineers India Limited. 20 years ago, we never used to see this kind of approach where a contractor will come and he will say, if you are giving me extension what I require, then it is fine, otherwise I will make prolongation claims of crores of rupees. 20 years ago, when these contractors used to come to us, consultant, they used to beg that, okay, you please grant me extension of time, don't apply liquidated damages, and I will finish my work. And we used to tell the contractors very swiftly that, okay, you just give us one statement in writing that you will not charge time-related claims, I will give you the extension. Because LD, claiming LD is none of the employer's business. They don't want to. But today, disputes are so many because of the fact that contractor or sometimes claimant is screwing, sometimes the extra intelligent forensic consultant has come and he has increased the greed of the contracting organization. So if a delay analyst performs his jobs perfectly, and by the way, I'm here referring the best industry practices like SCL and ACE both. Both have given a very categorically, very clear determination ways that how you have to determine. But because we don't apply them, we just want to sing the song of what your client wants, and that is where a dispute is being created. So please pardon me for language or some harsh standing on the subject. I would never owe when I am standing in front of the arbitrator tribunal, but these are the 4 contents which I really want to discuss and share with you that how it has to be done. The implementation of IAP and TIA, impacted as planned, and time impact analysis. These are the 2 prospective models which SCL has defined, that this prospective model. In one way, SCL is very correct because the most useful method during the execution of the project is because you have only these 2 options, especially if you are using Primavera softwares. So these 2 are prospective models, but sometimes I used to argue and I used to tell many forensic consultants would say that no, SCL has defined this as a prospective method, it cannot be a respective method. So I would again like to clarify that these methods can also be applied retrospectively. And there is a procedure called ACE 29R03 that lists this method. If you are doing the analysis using that particular method post completion of the project, these IAPs can be performed retrospectively also. So this part, generally, a lot of discussions, lot of argument happens by my counsel, by my other people that no, I do not agree. SCL says that this is a prospective. Yes, this is a prospective. Second important aspect is implementation of as planned, as built. Now this method, as planned, as built, is only applicable once you have completed the project. If you are applying it within the tenancy of the contract, within the execution period, then probably you have to apply the TIA, time impact analysis method. I will give you the major steps, what these methods stands for and how it has to be performed. The third important aspect of assessment of EOT and prolongation period. Many times I have been told why you are doing this. This is arbitrator's job. Many times lawyers also say, this is not your job, arbitrator will decide. But my argument is that being an analyst, I have to give him the basis, clear basis of what we consider as the likely EOT. Let tribunal overrule me. I have to give him the justification, the quantification period based on certain contractual conditions which we interpret as a professional. And then if tribunal overrules me, no problem. We can change our analysis based on his findings. So that is the controversial part. Within this EOT and prolongation, there are two, I would say predominantly two methods which are being used. These are dominant delay method and another is apportionment method. Usually dominant delay method is being used by English courts. I would say GCC countries is also using those one. But apportionment method is generally being used in USA or American continent. Then the last and the most important part, if the delay analyst will give his clear assessment of compensable delay, excusable delay, then there won't be dispute. The dispute is happening because somebody is writing opinions without giving the evidences or the quantum analysis. Ultimately, a delay analyst has to prove that 2 plus 2 is 4, not 22. And this can be done easily if delay analysts can do their job very simply and honestly. There are only certain ethics which are required to be done. I'll share some of the examples how this delay analysis is being done. So let's talk about the first analysis, impacted as planned and time impact analysis. I have wrote down the biggest challenge in India, let me be telling you, almost 95% of the baseline schedules are wrong. This is the biggest problem and this is the cause of the dispute. When engineer is approving, he is also not looking those. If your CPM program is not properly integrated, whatever impact analysis you are going to do, it will not move forward. The project completion date would not move forward. So, if a forensic expert is being engaged, first of all, the practice should be that a contractor should prepare a properly integrated CPM program, critical path method. Or precisely if you talk about the prima vista principle, it is precedence diagramming method. It is not CPM, it is precedence diagramming, PDM method. So every activity, when I see a baseline schedule of 1500 activities, I notice that the first activity itself, geotechnical investigation, that itself has got a 1356 days float. How can it be possible? If your survey is not done, then your design cannot be completed, geotechnical design. If your geotechnical design cannot be completed, your construction of bridges cannot start. So these things are logically integrated, things are not available in the baseline schedule. The first step is to have ensure properly integrated, logically linked baseline program. In the impacted as plant approach, one has to apply the fragment. What most of the delay analysts will do, they will apply the delay only. When I am saying fragment, you have to calculate what are the subsequent activities which are going to be affected on that particular path. A set of activities that needs to be applied, plugged it into the Primavera schedule, and then you have to see what is the scenario, when is the projection is happening. But that is not being done. People will just put employer's delay, and they will say, oh, employer has delayed so much. So obviously you don't get the right. What has happened previous to that, that also check. There are many cases like design review and approval. If contractor has not submitted design on time and subsequently the client has delayed, so suppose the contractual period is 21 days and client is responding in say 50 days, so contractor will claim that client has delayed, so he should get an extension of time. But he forgets that he has delayed the submission of drawing at the first instance because that was also falling on that particular path by maybe 200 days. So if people will connect, people will add it in an honest way, the fragment, these both analysis can give you a very logical result which both parties can agree. But it is not happening, and I will share with you some of the examples. If you are doing this, obviously the prospective models requires a CPM schedule to be utilized so that you can do the projections. So the CPM schedule you need to run, and once you have created a model for everybody's culpability, employer's culpability, the force majeure event, the contractor risk event, once you have modeled, so to find out what was the EOT entitlement, you have to go for a CRE is equal to 0 scenario. CRE is contractor risk event. So assuming that contractor has not made any delay on that particular path, you have to find out what is his entitlement of EOT. Because FME also, the client has to give the extension time. So these are some inputs which are required. What is the difference between impacted as planned and time impact analysis? When I say, of course, the corrected baseline plan is required in both the cases. The only difference is when you do the time impact analysis, the day you are doing the time impact analysis, you complete the actual status on that particular date. Up to that particular date, you have to update the Primavera, and then you insert or your delay event to predict what could be the projected completion date. So that kind of analysis is required. I think I'm very short of time, so Mohammed will definitely fire me. So now let's see one very interesting example. Almost everywhere, every project you will see right of way is given late. So what will happen? 90% of ROU, if you see, this is the top one is the baseline plan, where ROW and then design and then embankment and all this thing was supposed to done. And in the impacted program, the lower one program, you will see that instead of 100% ROU in 90 days, the employer has given the 100% ROU after 180 days. So what delay analyst used to do, and this is where the claimant becomes greedy, that he will just put one particular ERE, employer risk event of 180 days, and completely shift the schedule by 180 days. And he will say that this is my right. Sorry, this particular thing does not cater to the basic protocols set by the core principles set by the SCL. Core principle 15 says that you have to mitigate the risk if employer has done it. Now, what is the correct way then? The correct way is that because 10% of the land was only held back, 90% you had the front, 90% you were working there on site. So how can you say that all your activities happen? That is the previous case is purely hypothetical. You cannot claim But unfortunately, that is where the disputes start, because contractor will always say that this was my right. You have given late, so I have the right to 180 days. But it doesn't exist in arbitration. The fact is that because 10% work front was given delayed, so in that 10% delayed ROU, there could be only one bridge which might have been held up. So you get an impact assessment. Now you see that the basic durations for the original plan remains as it is. Only the 10% which is affecting the ROU, only that is affected, and then you may end up with a net effect of 30 days only. And this is reasonable. Everybody will appreciate, everybody will, even the tribunal would say that, yes, I agree, 90% of the front you are working, so what is the problem? Go ahead. So this is the method, because this protocol also sets this example that you have to apply the mitigations. And when you are especially working on the other fronts, 90% of the work, you cannot just claim that 180 days are required for this extension. So the third and most important, once the project is completed, you are doing the retrospective analysis, the most simplest way, and it is being used for years and years. It's simply a comparison of planned versus actual. But the unfortunate part of this particular analysis that you don't need a CPM software. It is a mostly observational method. You don't need critical path to be proved. In other methods, prospective methods, you were proving the critical path. But in this method, it is an observational method. You just observe what could be my critical path. So defining a critical path is a big challenge in AP/AB analysis. Because even if you have built the model or within the Primavera, the moment activity becomes 100%, you don't get float calculations. And once you don't know whether it is falling on, float calculations are not there, you cannot say that it is falling on critical path or not falling on critical path. So in observational method, especially in linear projects, you need to have a time location chart. That can give you my next particular slide. This is the time location chart. Define this on y-axis, you have months. On x-axis, you have the changes of where the work is being happening. The yellow part is telling you what utilities got delayed, which utilities has affected, and it is what we have done. We have plotted every 1 kilometer of change. That how time is over? Okay, okay. Should I wrap up? In 2 minutes. Okay. So this kind of particular chart, time location chart, will tell you exactly what particular change has been commissioned or has been energized at the latest. And that you have to backtrack there, that why, which facility has delayed. That if you see these arrows, these are showing the NTC movement track laying was to be done by using a NTC movement. So if NTC movement has to be performed, then all facilities within that channel must be completed. So with this, we analyze what could be the critical path, and then based on that, once we identify, observe the critical path, we have to perform this assessment of EOT and prolongation period. So guys, please excuse me. I think time is of great importance. I have to close it down. Mohammed has certain targets. So we can discuss maybe outside this particular room, or anytime. You are most welcome to come join me in my company. And I can always, but what is more important, many people will argue, in fact, sometimes lawyers argue that you cannot define tenability. You cannot define culpability. One has to remember that if any forensic analyst is not giving you a conclusion with excusable delays and non-excusable delays, plus compensable delays, if he is not doing the calculations, then he is just not doing professional justice with his profession. A delay analyst has to finally, he doesn't need to write opinions in multiple pages because of just one particular small issue. One particular small issue may not affect may not fall on the critical path. What is important that the ultimate conclusion should be derived using what is employer risk event on the critical path, what is contractor risk event, what is the applicable LD period, whether excusable delays were there on that particular path or not, whether non-excusable delays were there or not. And that is where the two dominant and the apportionment method is being applied. So we will discuss some other day, not today, but I would like to conclude probably how to define the concurrency also between the two different paths. That also I tried to explain, but probably the time required is little longer. So thank you very much indeed. It's a pleasure to be here.
Thank you, Manish, for that presentation and also for accommodating our rate of progress through the panel. I think what I will invite Atul to do is perhaps give us the other half of the story from the legal perspective. And then we heard a little bit about the dominant causes of delay and the approach to causation and concurrency. And we'll try and tie those two threads together with the discussion with the panel next. So can I invite Atul to just share with us some thoughts?
Yeah, thanks, Mohammed. I think we have had an overdose of the technical side. Oh. I'll go back to the drawing board. When we're talking of delay analysis, we are obviously talking in context of program. The baseline program, and what is a program is the biggest misconception within the community of lawyers, within the community of engineers, within the community of the business. Essentially, the basic question which we need to answer is, and I find it very strange, I'm in fact doing a challenge to a domestic award, where the program is, it's called L2 schedule and has been made a part of the LOA. Now, can a program be ever part of a contract? Is a basic question which we need to understand. Because if program is a part of the contract, then any deviation will be a variation. And if it's a variation, then it's going to lead to consequences which are never contemplated. So essentially a program, I think, at least from whatever I have learned, is something which is always moving. It's something which needs to change. And that is where all these consequences which you've heard very eloquently would come into play. Therefore, when you're doing delay analysis, is it something, again, the question, of course, Manish has tried to justify by saying it that it can always be done post. It's easier said than done, because a program, as I said, is something which is a moving goalpost. And if the activities within the program are moving goalposts, doing it retrospectively, it has its own problems. He might have the tools, and he can come in in the box as an expert and justify it. But the fact remains that this is something which is dependent on a large number of factors, which need not necessarily or may not necessarily be identified in a retrospective manner. And there are a large number of factors which could have implications on impacting the program. But the fundamental point is that what do we understand a program is? As I said, unfortunately, in the Indian context, we have not had a lot of jurisprudence on this. When I was doing my research, I realized there were only two judgments I came across, that to not Indian courts. One is the Queen's Bench Division of 1981, Yorkshire Water Authority, where the method statement was incorporated in the contract. And the court held that any breach will be a variation, and therefore it will have severe consequences. The other judgment I came across was the Scottish Court of Session, Outer House, 2015, Martifire UK versus Land, lease construction, where it was held that it would be unusual for contracting parties to bind themselves, and any departure from which will be a breach of contract. So the bottom line here is, that a program is flexible, and program is something to which we will look at for arriving at the delay analysis and attributing the delays of whatever kind, contractor, employer, concurrent. Now, coming to the linear projects, LSM is considered to be one methodology, but again, I believe that it is very difficult to use that tool in a retrospective manner, because ultimately everything will be governed by the facts, relevant facts, which has to be established on affidavit and cross-examination of the witnesses, which could include, areas where, apart from the technology of it, apart from Primavera, apart from the software that you are going to use, there will be a large number of things which could not be factored in those programs. The other problem with regard to the availability of tools for using LSM as a method is that it is not a very developed method, and we don't have, and subject to corrections, because I'm not an expert, I must make a disclaimer there that I'm not a technical expert in this regard. To my understanding, there are three softwares, Tilos, TurboChart, and Schedule Reader. Please correct me if I'm wrong, which are not available in India. And therefore, we have to take recourse to the standard CPM methodology in Primavera for arriving at the conclusions. So this is something which is yet to develop, and therefore taking recourse to something which the whole system, at least in this country, and I am sure I'm speaking for a large number of jurisdictions where it has not developed as yet, that we still have to take recourse to the overall totality, because CPM is something which is total, taking the schedule completion date and the events which are going to impact the progress. So program is something which ultimately will have to be dependent and on large number of factors, and what do you include in that. So far as the SCL delay and disruption protocol is concerned, I think the guidance, do not wait and see, is very critical. Because, so that inheres in it the fact that you can't be doing this kind of an analysis post. So therefore, if you are alive, so essentially, all these tools are, at the end of the day, contract management tools as a real solution to the problem. But I don't think that in real life it happens ever, that you have such a proactive contract management system developed in many countries, including India, where contract management is always considered as something which we will see later, let the project complete. And then we will come in and we'll see whether, there were issues we could have dealt with at that point in time. So contract management, I have been a quirk of fate. I've been involved in large number of implementation of infrastructure projects. And believe me, the whole approach is, let's move on. Let's not manage a contract. We had a team of our firm, 4 people, based on a project site. And I'm not saying it because we have done it, but our experience shows that if you manage the contract well, and you map the contract well during the implementation stage, and marry the implementation to the contractual provisions on a day-to-day basis, and don't leave any gaps for any disputes later on, you can have very few disputes, and all these become a thing of the past. And therefore, similar projects where we felt that we were very proactive, in one of the projects in last 10 years, 12 years, 2 disputes. Similar project somewhere else, I think there were about 40 disputes already in the last 10 years. Contractors, subcontractors, designers. So at the end of the day, what is critical is what is your program, how do you value your program, how you manage your contract, and how you make sure that you don't leave gaps within the contracting stage. And one of the key things which I believe is very critical and leads to a lot of disputes is the record keeping. It's typical of the contracting or the bidding team valuing certain items and then handing it over to the implementation team, and then a period of 5 years have gone. The gentleman who has valued that item or taken a call on pricing of a particular activity, there is no data available. So that handover is very critical. The record keeping is very critical. And most of the times, you lose or win a matter. I can say that with a certain degree of certainty because you don't have records. The other distinction factor which I believe is how we, in our jurisdiction in India, how do we look at the whole regime of compensating delays? I don't know about other countries, but sure in India, we have a section 1 of the Contract Act which says that anything which is, in effect it says anything contrary to the act is not going to be enforced. In fact, most of the decisions, the awards that I have come across have not dealt with this question. There's one award, and I can talk about it because it went to a challenge. There's a judgment of the Delhi High Court. This was in respect of certain oil storage caverns, 2 projects, Padur and one more, where the view taken is that any clause within the contract which limits the right to award compensation for delays would per se be not, per se would be violative of Section 23 against public policy. So that's an element which we need to take care of. And that is all the more a reason that we must have a very robust contract implementation, because leaving it for the posterity is going to lead to a lot of complications. Thank you.
Thank you for that. So I think there are 2 strands we can pick up from that series of presentations. The first strand I'd like to take up with the lawyers on the panel, if I can, which is just perhaps looking at it from the sort of fundamental principles that underlie these sorts of problems of delay, causation, and damages. Richard, perhaps I can start with you in terms of things like the prevention principle and your experience in other jurisdictions, that how they approach these sorts of fundamental issues of causation and effect.
Well, I'll just deal briefly with the prevention principle and give you something a little controversial to keep you awake on a Sunday afternoon. So the principle itself is an employer can't benefit from his own wrong. So he can't prevent the contractor from completing and complying with his obligation to complete on time and then be entitled to liquidated damages for late completion. He can't cause the delay and then claim compensation for the delay. And the prevention principle means that the effect of the employer's delay is to put time at large, and then the contractor's only obligation is to complete within a reasonable time and not by the agreed date. So the effect of that is if the employer causes delay, he loses his right to the agreed liquidated damages. That's the principle. It generally doesn't apply. It's generally irrelevant because if there's a contractual mechanism to change the date for completion to allow for the delay caused by the employer, then there's no benefiting from the wrong caused by the employer. And the name of that clause is an extension of time clause. And I'd be surprised if you see many construction contracts without an extension of time clause. And when that is operated, the employer doesn't benefit from his own wrong to the extent of the delay he has caused because the completion date is moved to that extent. And extension of time clauses are there for the benefit of, at least under the common law, for the benefit of the employer. because if there was no extension of time clause, time would be at large and he'd lose his right to liquidated damages. So it's for the employer's benefit to move the date for completion and say, contractor, you've not completed by that date for completion, therefore I am still entitled to my agreed liquidated damages. Because remember, for employers, if they can't get their liquidated damages, they may be in great difficulty proving any other general damages and loss. So prevention and time at large are now really only relevant if there's an extension of time clause that's been very badly drafted and just doesn't cover the employer's act which caused the delay. And that is incredibly rare. That's the position under the common law. I'll just briefly mention under the civil law, so Europe, Middle East, these are principles that are simply unknown.
Thank you for that. Samir, can I draw you into this distinction, this discussion, and look at it from the perspective of Indian contracts and Indian projects?
Right. So I think of course, Richard talked about extension of time. So there are three issues which always arise together: extension of time, liquidated damages, and prolongation costs. Now, first two are a little less controversial, and I think because we have Supreme Court judgments, the basic principles are very clear. Time is never the essence of the contract in India for these kinds of contracts, especially if they have an extension of time clause. So again, and they do rely on the prevention principle and explain that once you have a provision for extension of time, you must apply. And if you fail to apply, one judgment, of course, says that time would be at large. So irrespective of the nature of the clause, it would be at large, and no liquidated damages can be imposed. But I think the question that you're asking probably relates to prolongation cost. And there I, of course, slightly differ with what Manish said. Prolongation cost in India, we have most contracts even now do in fact specifically bar grant of prolongation cost. So what happens is that, of course, the contract will have a provision which will say, we'll give you time but no money. Now what's the consequence of that? Luckily for contractors in India, the law is very clear. The specific provisions for delay and consequences arising therefrom. So therefore, even without going into whether that clause is valid, void, etc., you can make a claim for damages outside the contract, because a claim for damages is always outside the contract. And courts have always upheld the grant of such amounts starting from at least the early 80s, there are a series of judgments. And finally, it's a matter of balancing risks. So the point is, again, and that's where I'm disagreeing with Manish, where the contractor has decided, and now why are there more and more cases which are arising? The project sizes are becoming larger, amounts involving are becoming larger. The equipment, now you have for laying rails, you have machines, for tunneling, you have machines, more expensive. If they lie idle, costs will arise. Therefore, if there is delay, there will be cost, of course. The question of proving who is responsible for the delay always remains. But no contractor can absorb the risk of such large delays because his costs are very high now. And therefore, the law allows you damages, irrespective of the contract clauses. And there is now enough law to say that such clauses are invalid under Indian law. So that's how it's structured, and I think it's a balance. And an arbitral tribunal or a court will draw a balance and try to say, find out who's responsible and therefore compensate the party who's not at fault.
Sure. Manish, I'll preserve your right of reply, don't worry. But Garry, I'd just like to draw you into discussion in terms of the fundamental approach to dealing with such challenges in terms of delay and progress, and how you see the methodologies having an impact when it comes to things like prolongation.
Yeah, I mean, in that context and tying up with what Richard said about the completion dates, and I think what Atul mentioned about the baseline program, I think we all need to remember here, particularly the legal people here, is a program is the contractor's estimate. It's a guess as to how he's going to finish these works in the set period that the contract states. Typically, his only contractual obligation is to finish by the completion date. The order in which he does it, the sequence and how long he takes with all the individual activities doesn't matter, as long as he achieves the completion date. Where we get tied up with this is people now use his baseline program as a tool to hit him. Say, you said you were going to finish that activity here and you didn't, so we're going to analyze that. We need to maintain that it is an estimate, a guess. And so therefore, it's a concern from my perspective that people get tied up too much with the baseline program when analysing delay. But coming back to the point, ultimately, as John Prudo said yesterday, or Big John said yesterday, delay analysis as a concept is quite straightforward. This is what was planned, this is what actually happened, and it's facts. And the analysis should be focused on that. And the analysis shouldn't be focused from a retrospective perspective on a dynamic analysis of programs, whether it's time chainage, LSM, or CPM. At the end of the day, we can demonstrate graphically, either with software or just with you creating our own charts, when and where delay actually accrued and where the actual critical path likely was. And so, people get too tied up, I think, in making it more complex than it really is.
Manish, can I draw you in with your right of reply, but also your thoughts on how important really is the baseline program if it's a dynamic thing and an estimate?
See, the contractor always gets opportunity to revise it. The contract is very clear, and or even FIDIC is very clear, that whenever there is a progress deviation, engineer can issue an instruction and contractor has the opportunity to revise the contract. Unfortunately, although this is I always believe this is for the benefit of the contractor to revise it, because when you are submitting within the first 28 days, the contract is awarded, you may not have that kind of clarity how execution is going to happen. But 6 months down the line, if any delay event has happened and you have asked for any EOT, if engineer has given you a determination, it's always better to rectify the baseline program so that it becomes more predictive that how things are going to happen. So, in my opinion, I would say that there is a provision of revision of schedule, the contractor, and moreover, there is a provision of every monthly update. If the analyst, programmer is updating the schedule correctly and with ethical practices, he can predict the project delays in the beginning. And that is where we always say that there is an early warning system which only CPM program can provide. Not every software can provide a CPM program. If the baseline is properly done, it can provide you an early warning system that where you are heading towards. So this is one aspect. One aspect which I would like to address to Samir sir. I never said, sir, as an expert, I all do calculate prolongation cost for everyone. I'm telling you the 20 years ago when the contractor used to come, they used to admit their mistake and they never used to go for the prolongation claim. I totally agree. The sizes has become very big. The liabilities has become very big. I would not say that you should not apply for the prolongation. You must, if you feel that you deserve. But for that purpose, you need to have a delay analysis which should be able to prove what was the compensable delay. That compensable delay can only define the prolongation cost. Not just because that whatever delay has occurred beyond the schedule completion day, it is all employers. And this is where the disputes are happening. If people will do the proper excusable delays, the non-excusable delays, the compensable delays, the calculation, because ultimately 2 plus 2 has to be proved on 4, not 22. And this is where the gap lies.
Okay, I think that's an excellent opportunity to move on to the final topic in our title, which is concurrent delay, and perhaps talk candidly about contractors confessing to their own culpable events.
So we saved the best till last, and I'm going to keep you awake this Sunday afternoon with something even more controversial, and that is that concurrent delay is almost always wrongly referred to and used. So what is it? It's two causes of critical delay, both of equal effect on completion. One is the contractor's responsibility, the other is the employer's. And critical delay is usually alleged by employers because they want to contend, or they do contend, that where there's critical delay, the contractor is entitled to an extension of time and therefore a reduction in liquidated damages, but he's not entitled to prolongation costs. So it's usually relied on by an employer as a defense to a claim for prolongation costs. So you, Mr. Contractor, were in delay at the same time that I, the employer, caused the delay. But, in fact, concurrent delay is rarely relied on properly. So, in fact, it's very rare that concurrent delay occurs, because there must be two delays, both of which are critical, causing delay to completion, and the same delay to completion. And it's possible you have two activities that both are delayed and have the same equal effect on completion, two separate activities. That's very rare. And what it is not is two bars on a bar chart that are in the same place. A very senior member of my chambers, Keating Chambers, once gave a talk saying that critical delay was invented in the 1980s, and it arose with the advent of computer bar charts illustrating delay. And people noticed that there were two delays that seemed to overlap. So there's concurrent delay and there's a defense there. But before people started putting these things on bar charts, it was effectively unheard of. But it is not a critical delay where a non-critical delay occurs at the same time as a critical delay. That's not concurrent delay that has any effect on the contractor's entitlement. More relevantly, there may be multiple possible causes of a delayed activity on the critical path. So you've identified an activity that was on the critical path and delayed, and the cause of that delay might be more than one thing. For example, the earthworks were delayed due to a lack of access, and also because the contractor didn't have his equipment on site. But the cause of the delay, is a question of fact, not expert opinion. So the lawyers, with their access to the documents and the witnesses, need to demonstrate what the actual cause of the delayed activity was. And so not only is it very rare that delay experts will identify genuinely concurrent delays, but it's very rare that tribunals will say, we simply can't decide what the cause of the delay was. Tribunals will almost always decide which of the competing allegations was the cause of the delay to that critical activity. Now, if there is real concurrent delay, what is the legal effect? Well, you still get an extension of time as the contractor, because the cause of the delay falls within the extension of time clause. In other words, it's one of the listed causes of delay, so the contract says you get more time. And the argument about no money is that the contractor's going to be on site longer as a result of his own delay, so the employer's delay at the same time didn't cause any additional prolongation costs. So there's no loss, no additional loss or cost as a result of the employer's breach. So I'm not going to tell you that concurrent delay is total fantasy. It has a theoretical basis, but once you apply the proper analysis and analyze the facts, it almost never occurs. So how do we do the analysis? Well, often what you see is a first analysis looking at the delays for which the employer is responsible, and then do it all again, saying, oh, well, yes, that we may be responsible for all these delays, but Mr. Contractor, once you look at concurrent delays, you delayed everything here, here, and here. That is not right, because what you are almost inevitably doing with a second analysis is identifying non-critical delays on a bar chart that happened at the same time. So where I started, that is just not the right approach. And so the excuse that the employer has, he's looking for these non-critical delays that happened at the same time, and he's saying, because all these things were delayed by you, I didn't cause you additional cost. But the definition of critical delay, critical activities in the critical path, is what caused additional time for the contractor on site. So unless the contractor's delays affected activities on the critical path, they are irrelevant to his claim for prolongation costs. So there must be concurrent critical delays that we're looking at. So what we need to do for the analysis is look at what activities were on the critical path in a particular window, and then say, are there two which genuinely cannot be separated? And then where there's one activity and two possible causes, one the employers, one the contractors, then, as I mentioned, there's a question of fact. First of all, whether they're really equal causes or not, or is one the real cause and the other possibly the effect? And a tribunal is always going to want to make a decision on that based on common sense. So, for example, a contractor had no men available, so lack of access didn't cause delay, or did the contractor have men, maybe he didn't have men available on site because there was nothing for them to do because he didn't have access. That is not a question that's going to be answered by a delay expert. It's going to be answered by documents, and more likely the witnesses. You bring the project manager along and he said, well, there's no point in mobilizing labor today because there was nothing for them to do. And so you identify what was the real cause of delay. And finally, and almost most importantly, tactically, there is no point in an employer alleging concurrent delay. For the employer, why should he not just try and show that the delay was caused by matters for which the contractor was solely responsible? So you've identified your critical activity, you've identified that there are two potential equal causes for the delay to that activity. Why say, oh, we both caused the delay? Tactically, why does the employer not just say, your delay was the real delay and the cause of delay? And the result of that wouldn't be a concession that there was an entitlement to an extension of time, and the employer would retain his right to liquidated damages in respect of that delay. So in summary, I think that the analysis of critical delay by experts has gone too far and is unhelpful. Generally, as a factual matter, the tribunal will decide one delay and not the other and won't conclude critical delay. And finally, it's not in the employer's interest to allege it anyway.
Thank you for that, Richard. It sounds like this is a kind of a tactical mistake that is being made in the presentation and defense of delay claims. And I wonder if I can generalize that question, maybe starting with Samir and coming back. What do you see in like 10 seconds as the major mistake or common mistakes that are being made? And what can contractors and employers do better?
No, so if I can just take the 10 seconds to respond to what Richard said. So the new issue which is arising is that when there is in fact a concurrent critical delay, but subsequently the contractor speeds it up. Now, if you go strictly by the SCL protocol, it still remains a non-compensable. But because you actually speed it up later, it no longer remains critical. And therefore, my argument, which is actually live in coincidentally 3 matters, is that does it remain a concurrent critical delay if you've accelerated and actually gotten over that delay, which is the contractor's delay. So that's what I would, that's an issue very much live for me. And let's see how it goes.
Manish?
Yeah. So the biggest challenge, I would say that the employer has to be more pragmatic in risk allocation while preparing drafting the contract so that disputes can be avoided. And a good delay analyst, a honest, professionally, ethically correct delay analysis has to be performed so that it should be for the benefit of everyone. Of course, I will lose the business, lawyers will lose the business, but that's how the industry has to grow up. That's my request.
Atul?
I think, to me, the allocation of risk is the biggest factor which has led to a large number of disputes, and I think it goes to the root of the matter, that we need to have a standardized contracting regime in India. Today what we have done is we have done violence to FIDIC in every form. And when I started practice, it used to be either PWD contracts or CPWD contracts. I precisely knew what the animal was like. Today you have a hash of public contracting documents, which has led to all these kinds of problems.
Garry, last words.
Yeah. To all the lawyers out there, stop asking your delay experts how you're going to deal with concurrent delay. Okay? Concurrent delay is a contractual issue for the lawyers to deal with as to how it's defined and how it's to be treated in the analysis of delay. If it's not in the contract, it's a legal issue that has to be dealt with. As an expert, I will do an analysis which shows this is how we planned and this is what actually happened. How you determine and treat concurrency from a contractual legal perspective will not change my analysis. Things started here and finished here. How you treat concurrency doesn't change my analysis. What it does, depending upon how I'm instructed or how I'm told counsel is going to argue concurrency, it may mean I present it's slightly different because of the way they want to argue what concurrency means. It doesn't change my analysis. So stop asking technical people how they're going to deal with concurrency in their analyses.
Okay, thank you everyone. That brings us to the end of the panel. I have a bright red time's up here. So all that remains for me to do is to thank our panelists for their insight, their expertise, and their candid sharing, and invite you to share questions with them afterwards.
Thank you, Mr. Talib, and my sincere appreciation to the entire panel for bringing such clarity and depth to the subject. I would now request Mr. Bruce Reynolds to kindly felicitate the speakers.